What would you do if a mate bought you a drink and before you had the chance to sip on the tall iced coffee in a grande cup with extra ice, 3 pumps hazelnut, 2 pumps cassic, an int of non-fat milk with a dome lid, a small cockroach crawled out of the venti straw? You are about to find out. Welcome to our podcast on tort law, a foundational topic for SQE candidates and first-year law students. This podcast contains the key elements of the law of tort in 2025, revised and extended to reflect the significant legal developments of recent years and to provide a deeper understanding of its core principles. We start with a presentation of the origins and development of tort law before discussing the basis of liability. We then explain in detail the modern concepts of the duty of care, standard of care, causation, remoteness, and defences. We pay specific attention to claims for battery, assault and false imprisonment before concluding with a discussion of the crucial modern torts of defamation and misuse of private information. This podcast has been prepared by Dr. Yannis. Have a look around his YouTube channel, especially if you are an SQE candidate. Without further delay, we start with a short introduction to the origins and development of tort law, a key part of the common law system that shapes many legal principles and everyday interactions. To understand tort law today, we need to look back at its historical roots. Tort law, as we know it, evolved from early medieval practices in England, where the primary goal was to maintain public order and peace. The royal courts began asserting jurisdiction over disputes involving trespasses. These were direct infringements upon a person's body or property. At its inception, tort law was closely intertwined with criminal law. Actions like battery, assault and false imprisonment were not just private wrongs, but breaches of the king's peace. This dual nature shows how tort law originally aimed to address violent deeds directly affecting individuals or their property. By the 13th century, actions for trespass became more formalised, allowing plaintiffs to bring cases for direct injuries. However, the court soon recognised the gap. Not all wrongs were direct. Thus, the action on the case emerged to cover indirect injuries. Unlike trespass, which required the defendant's action to be forceful or direct, the action on the case could address a wider range of wrongs, such as nuisance or defamation. This marked a significant development, broadening the law's scope to include more subtle forms of harm. In the early days, bringing a case to court required a specific writ, a formal written order from the court, defining the nature of the claim. Writs played a crucial role. They provided the structure for legal actions and ensured that each case fell within a recognised category. Over time, however, the strict formalism of writs became problematic. The rigidity of these forms made it difficult to address new or unique harms that didn't fit neatly into existing categories. By the 19th century, reforms such as the Common Law Procedure Act of 1852 and the Judicature Acts of the 1870s abolished the old forms of action. This was more than a procedural simplification, it was a profound philosophical evolution. Freed from the constraints of specific writs, the courts could develop a general principle of liability based on a duty to avoid causing foreseeable harm. This procedural reformation was the direct catalyst for the substantive revolution that culminated in the landmark case of Donoghue v. Stevenson. The Lord Atkin's neighbour principle provided the unifying concept that the old writ system lacked. This shift from form to substance is arguably the single most important development in the history of tort law, as it enabled the tort of negligence to become the dominant cause of action it is today. Let us focus now on a crucial aspect of tort law, the interest it protects, and the different bases of liability.
At its core, tort law is about safeguarding fundamental human interests against wrongful conduct. Think of it as a way for the law to step in when someone's rights are violated in a way that causes them harm or loss. But not all interests are protected equally. The highest priority is given to personal and proprietary interests. These include the protection of one's body from harm, freedom from physical restraint, and the protection of tangible property like land and goods. Beyond these, tort law also recognizes the importance of reputation and, more recently, privacy. Torts like defamation are designed to protect individuals from false statements, while the modern tort of misuse of private information safeguards personal data and seclusion. It is important to distinguish tort from contract law. A key difference is that liability in tort is predominantly fault-based, whereas liability in contract is, prima facie, strict. While tort law's central concern is to provide a remedy for physical damage to persons or property, contract law's primary function is to protect economic interests and enforce expectations arising from an agreement. Now let's shift to the different bases of liability in tort law. There are three main types: intentional conduct, negligence, and strict liability. First, intentional conduct. This is where the defendant deliberately engages in actions that infringe on another's protected interest. For example, in the case of battery or assault, it's not enough that harm occurs, there must be an intent to perform the harmful action. Second, we have negligence. Negligence is about failing to meet a standard of care that the law expects. It doesn't require a deliberate act, but covers situations where someone fails to act as a reasonable person would, and as a result, someone else suffers harm. This is the most significant area in modern tort law, covering everything from car accidents to medical malpractice. Finally, there's strict liability. This is the most straightforward but also the most stringent basis for liability. Under strict liability, a defendant can be held responsible for certain harms even if they were not negligent or did not intend to cause harm. This typically applies in situations where the law wants to encourage extra caution, such as with dangerous animals, for example, under the Animals Act 1971, or defective products, for example, under the Consumer Protection Act 1987. We're now diving into one of the most fundamental concepts in negligence, the duty of care. This area has seen a landmark clarification from the UK Supreme Court, and it is crucial for students to understand the modern framework. For a negligence claim to succeed, it's not enough just to show that harm occurred, there must also be a duty of care owed by the defendant to the claimant. The modern understanding of this duty begins with Lord Atkin's famous neighbour principle in Donoghue v. Stevenson, where he stated, "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour." For many years, in new or difficult cases, the existence of a duty of care was determined by the three-stage test from Caparo Industries Plot v. Dickman, which asked whether harm was foreseeable, whether there was a relationship of proximity, and whether it was fair, just, and reasonable to impose a duty. However, the Supreme Court's judgment in Robinson v. Chief Constable of West Yorkshire Police in 2018 fundamentally changed this approach. The Supreme Court in Robinson stated that the idea that the Caparo test applies to all negligence claims is a mistake. The correct approach is to look first to establish legal principles and precedent. In a vast number of situations, such as those involving drivers and other road users, doctors and patients, or employers and employees, a duty of care is established by long-standing authority. In these cases, there is no need to resort to the Caparo framework.
The Caparo test is now reserved for novel cases. It is to be used only where established principles do not provide an answer, and the law must be developed incrementally and by analogy with existing authorities. A crucial aspect of the Robinson analysis is the distinction between causing harm through a positive act and failing to prevent harm and omission. The Supreme Court affirmed that public authorities, including the police, are subject to the same principles of negligence as private individuals. They are generally under a duty of care to avoid causing foreseeable personal injury through their positive acts. In Robinson, the police officer's attempt to arrest a suspect in a busy street was a positive act that created a foreseeable risk of injury to pedestrians. Thus, a duty of care was owed to the 76-year-old claimant, who was knocked over in the process. Conversely, the common law does not typically impose liability for pure omissions, such as a failure to prevent harm caused by a third party. A duty to act in such cases will only arise in exceptional circumstances, for instance where there has been an assumption of responsibility. Once a duty of care is established, the claimant must prove it was breached. This involves assessing the defendant's actions against the standard of care. The standard is primarily objective. It does not focus on what the defendant actually knew, but rather on what a hypothetical reasonable person would have done in similar circumstances. One of the key cases illustrating this is Bolton v. Stone. In this case, a cricket ball hit a passerby outside a cricket ground, but it had only happened 6 times in 30 years. The court found that the cricket club had not breached its duty of care because a reasonable person wouldn't have taken extra precautions against such a rare event. However, courts take into account several factors such as the likelihood and seriousness of harm, the cost of taking precautions, and the social utility of the defendant's conduct.
For example, in Paris v. Stepney Borough Council, the court held that more precautions were required when an employee with only one eye was exposed to risks that could cause blindness in his remaining eye. Here, the severity of potential harm justified a higher standard of care. In the context of professional negligence, this standard has undergone a radical transformation, particularly in medical cases. For decades, the standard was governed by the Bolam test, from Bolam v. Freien Hospital Management Committee, which holds that a professional is not negligent if their conduct is supported by a responsible body of medical opinion. This was later refined in Belotho v. City and Hackney Health Authority, which added that the professional opinion must be capable of withstanding logical analysis. While the Boland and Belotho tests still apply to the purely technical aspects of medical practice, such as making a diagnosis or performing surgery, they have been superseded in the specific context of a doctor's duty to advise a patient on treatment risks and alternatives. The governing law here is now the Supreme Court decision of Montgomery, the Lanarkshire Health Board. Under the Montgomery test, a doctor is under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative treatments. The test for materiality is patient-centric. A risk is material if a reasonable person in the patient's position would be likely to attach significance to it, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. This requires the doctor to engage in a dialogue with the patient to understand their specific concerns, marking a definitive shift away from medical paternalism towards a model of patient autonomy and shared decision-making.
Causation and remoteness. Even if a duty of care has been breached, a claimant must still prove that the defendant's actions caused their harm and that the harm was not too remote. The basic test for causation is the but-for test. Would the harm have occurred but for the defendant's actions? A classic case is Barnett v. Chelsea and Kensington Hospital Management Committee. A man who'd been poisoned with arsenic was sent home from the hospital without treatment. He died, but the court found that even if the hospital had treated him, he would have died anyway. Therefore, the hospital's negligence did not cause his death. But causation is not always straightforward, especially with multiple potential causes. This is where the courts have developed alternative approaches, such as the material contribution doctrine. An important recent clarification comes from the Court of Appeal in Holmes v. Potent Holdings Ltd. It clarified that the material contribution to injury test from Bonington Castings v. Wardlaw can apply to indivisible injuries, such as Parkinson's disease, not just divisible ones. Although Holmes ultimately failed on its facts, the principle provides an alternative pathway to establish causation where the strict but-for test would be impossible to satisfy. This must be distinguished from the exceptional material increase in risk principle from Fairchild v. Glenheaven Funeral Services, which applies in circumstances of profound scientific uncertainty, most notably in mesothelioma cases, where it is impossible to prove which employer's breach caused the disease. The chain of causation can also be broken by a novus actus interveniens, or a new intervening act, if it is unforeseeable. Finally, the concept of remoteness limits the types of harm for which a defendant can be held liable. The harm must be of a kind or type that was reasonably foreseeable, as established in the Wagon Mound No. 1. This doesn't mean the exact sequence of events needs to be foreseeable. In Hughes v. Lord Advocate, an explosion occurred after a boy knocked a paraffin lamp into a manhole. Even though the explosion wasn't predictable, the court held the defendants liable because it was foreseeable that leaving dangerous equipment unattended could lead to harm. This is qualified by the eggshell skull rule, which states that you must take your victim as you find them. In Smith v. Leachbrain & Co., a man's minor burn led to cancer because of a pre-existing condition. The defendants were held liable for the full extent of the harm. Defences to negligence. Even when a claimant establishes all the elements of negligence, a defendant can still avoid or reduce liability by successfully arguing a defence. The two key defences are contributory negligence and voluntary assumption of risk. Contributory negligence is the most common defence. It occurs when the claimant fails to take reasonable care for their own safety, and this contributes to their harm. Under the Law Reform Contributory Negligence Act 1945, the court will apportion damages based on each party's share of responsibility. For example, in Froome v. Butcher, damages were reduced because the claimant was not wearing a seatbelt. Voluntary assumption of risk, or volenti non fit injuria, applies when a claimant voluntarily accepts the risk of harm. If successful, this is a complete defence. However, the defendant must prove the claimant had full knowledge of the specific risk and voluntarily agreed to assume it. In Morris v. Murray, where a claimant willingly got into a plane with a pilot who had been drinking, the court found the claimant had accepted the risk. But courts are reluctant to apply this defence, preferring the more flexible approach of contributory negligence.
We will now look at a series of torts based on intentional conduct.
Battery. At its core, battery is an intentional tort that involves direct and intentional contact with another person without their consent. It's important to know that this contact doesn't have to be harmful or violent. It just needs to be unwanted and unpermitted. The key elements are a positive act by the defendant, unpermitted contact, and directness. The intention required is not an intention to cause harm, but merely the intention to perform the act itself. Defences include consent, either explicit or implied, and self-defense, where a person uses reasonable and proportionate force to protect themselves. Assault. Unlike battery, assault involves no physical contact. It is about the apprehension of imminent contact. Assault occurs when one person creates in another a reasonable fear or expectation of imminent harmful or offensive contact. The classic example is raising a fist as if to punch someone. The key elements are an intentional act by the defendant, a reasonable apprehension of immediate contact, and the defendant's intent to cause that apprehension. A future threat like, "I'll punch you tomorrow," does not qualify. False imprisonment. False imprisonment occurs when one person unlawfully restricts another person's freedom of movement. This doesn't necessarily mean locking someone in a room. It can be as simple as preventing someone from leaving a particular place. The key is that the restriction must be total and without lawful justification. There must be no reasonable means of escape. Interestingly, the claimant does not need to be aware of their confinement at the time it happens. The main defence is lawful authority, for instance, a police officer acting under a lawful arrest warrant. In R. Jallow v. Secretary of State for the Home Department, 2020, the Supreme Court reaffirmed that an unlawfully imposed curfew met the definition of false imprisonment, confirming that the common law tort can offer broader protection than that guaranteed by the European Convention on Human Rights. Torts affecting reputation and privacy. This area of law has seen rapid and transformative development. The law of defamation protects an individual's reputation from unjust harm. For many years, in cases of libel, defamation in a permanent form, damage to reputation was presumed upon publication. This has been fundamentally changed by the Defamation Act 2013. Section 1.1 introduced a statutory threshold. A statement is not defamatory unless its publication has caused or is likely to cause serious harm to the claimant's reputation. For bodies trading for profit, Section 1.2 adds that serious harm means serious financial loss. The meaning of Section 1.1 was definitively settled by the Supreme Court in Lashaw v. Independent Print Limited, which held that serious harm is not to be inferred from the meaning of the words alone. It is a factual requirement that the claimant must prove on the balance of probabilities. This means the court now considers the actual impact of the publication. A gravely defamatory statement published to only a handful of people, or to an audience that did not believe it, may fail to meet this threshold. This creates a significant preliminary hurdle that claimants must overcome, rebalancing the law in favour of freedom of expression. Alongside defamation, a modern tort of misuse of private information has evolved, heavily influenced by the Human Rights Act 1998. This tort protects private information even when it is true, balancing the right to private life under Article 8 of the ECHR with the right to freedom of expression under Article 10. The legal framework involves a two-stage test. 1. Did the claimant have a reasonable expectation of privacy? If so, does the claimant's interest in privacy outweigh the publisher's interest in freedom of expression? The current leading authority is ZXC v. Bloomberg LP 2022. The Supreme Court held that as a general rule, an individual who is the subject of a criminal investigation has a reasonable expectation of privacy in respect of that information prior to being charged. The rationale was grounded in the significant and often irreversible reputational damage that can be caused by such publications, which undermines the presumption of innocence.
This decision highlights a significant convergence between the two torts, by confirming that an individual's reputation can fall within the scope of their private life. The Supreme Court has established that the privacy tort can be used to protect against reputational damage caused by the publication of true statements. Land-based torts and economic interests. The Occupiers Rehabilitation Acts 1957 and 1984 established the duties owed by occupiers of premises to visitors and trespassers, respectively. An occupier is a person who has a sufficient degree of control over the premises, as seen in Wheat v. Laken, where both the owners and the manager of a pub were deemed occupiers. Under the 1957 Act, an occupier must take reasonable care to ensure a lawful visitor's safety. This duty is higher for children who may be less aware of risks, as in Glasgow Corporation v. Taylor, where defendants were liable for failing to fence off poisonous berries. However, responsibility may also fall on parents to supervise young children. Conversely, trade visitors like the chimney sweeps in Roll v. Nathan are expected to appreciate and guard against risks inherent to their profession. Under the 1984 Act, a more limited duty is owed to trespassers. The statutory test, Section 1.4, is to take such care as is reasonable in all the circumstances to see that trespassers are not injured by reason of the danger, a clearer formulation than the older shorthand of common humanity. This duty only arises if the occupier is aware of a danger, knows or has reason to believe a trespasser may encounter it, and the risk is one against which protection is reasonably expected. Recent case law illustrates these principles. In White Lion Hotel v. James 2021, a hotel was found liable for a guest's fatal fall from a window with an exceptionally low sill. Breach was found under the 1957 Act with a 60% contributory negligence reduction. In Judge v. John Lewis Partnership plc 2023, the Court of Appeal found that a curb in a car park was an obvious danger, there was limited control by the defendant, and there was no duty to warn. Nuisance. Private nuisance addresses indirect interferences affecting the use and enjoyment of land, such as noise, smells, fumes, and, following recent authority, even intrusive viewing. In Fear v. Board of Trustees at the Tate Gallery 2023, the Supreme Court held that the use of a public viewing platform that enabled sustained visual intrusion into neighbouring homes could amount to private nuisance, while emphasising that ordinary overlooking between residential properties will not usually suffice. Only individuals with a proprietary interest in the land can sue. The key question is whether the defendant's use of their land is reasonable, which depends on factors like the character of the neighbourhood, the duration of the interference, and any malice. Public nuisance, on the other hand, concerns activities affecting the public's reasonable comfort and convenience. A crucial update is that the Police Crime Sentencing and Courts Act 2022, Section 78, abolished the common law offence of public nuisance and replaced it with a statutory offence. However, this reform did not abolish the tort of public nuisance. A private individual who suffers special damage over and above that suffered by the public at large, can still bring a civil claim. Pure economic loss and defective property. The law on recovering the cost of repairing defective property has been transformed. The old common law rule from Murphy v. Brentwood District Council, which held that such pure economic loss was generally irrecoverable in tort, has been significantly reshaped by landmark legislation and recent Supreme Court authority. In response to the Grenfell Tower tragedy, Parliament enacted the Building Safety Act 2022. Among other things, Section 135 radically extends the limitation periods for claims under the Defective Premises Act 1972. 15 years that claims accruing after 28 June 2022, and a 30-year retrospective period for claims that accrued back at 28 June 2022. This has revived a vast number of claims that were previously time-barred. Crucially, in URS Corporation Limited v BD Trading Limited 2025 UK SC 21, the 21st of May 2025, the Supreme Court confirmed that a developer who had remediated dangerous defects could recover its reasonable remediation costs from a negligent design consultant, even if the developer no longer owned the properties and without need for prior third-party claim. The decision aligns the common law with the BSA's policy of ensuring liability for dangerous defects is passed up the chain to the original wrongdoers. This concludes our updated and expanded podcast on the law of torts. Have a look around Dr. Yannis' channel for more podcasts on key legal topics.